This is the initiative, the Hoover Institution Initiative on Regulation and the Rule of Law, which Michael and I co-chair, and we're very pleased to see you all here today. We have a great group of papers, and we also have, we're very pleased that we have our friend Peter Wallison, who will be speaking to us over lunch. Make sure you've got the current version of the agenda. There was a flawed version that has been completely expunged from our memories, but in case you don't have it, Peter will be our lunch speaker, and we're very pleased to have him here. If you're not familiar with his book, Judicial Fortitude, you'll be more familiar with it over lunch. As all of you know, we've been meeting now for several years. What's this, our 5th year? We're finishing up our 5th year, I think, of the Regulation and Rule of Law Initiative. And our mission, I'm going to define it, is to talk about regulation and the rule of law. And there's, you know, in our first meeting, we raised a lot of issues, and Jennifer Arlen, who's a member of our group, was raising with me in some emails and with Michael some interesting points, going back to those. So I think it is useful to go back and remember a little bit of the journey that we've gone on. I don't want to take too much time, but just to say a little bit about it. This whole thing started with Alan Meltzer, who's a great fundraiser, who really, his fundraising abilities were a big part of the reason we're all here today. So it's always good to remember that and to remember him, who unfortunately is no longer with us. Alan died, about 2 years ago. And his concern was that there were changes in the American legal practice that were deviating from the rule of law, especially in the regulatory realm, and that these process concerns were really undermining the vision of American government that our founders had laid and that we all benefited from. And we talked a lot about process, for example, using maybe excessive discretion in the regulatory process to the point where formal rulemaking wasn't really being relied on anymore, but rather guidance or excessive prosecutorial discretion or other kinds of things. That was one piece of it. Another piece of it was the rise of the administrative state and the location of a variety of powers in one powerful entity, which was contrary particularly to Madison's definition of tyranny, the fact that the SEC sets rules, imposes taxes, they call them fees, and also adjudicates disputes, would make them, of course, very contrary to Madison's vision of the separation of powers. And then finally, the fact that Congress has weakened itself. And I emphasize that the judgment of the group that we had, even in our first meeting, was that most of the weakening of Congress, which was deteriorating the self-government of the people, was the result of Congress's own decisions to weaken itself. And so it was those kinds of things that motivated us, a kind of lack of adherence to constitutional order and a lack of adherence to due process, that really have motivated us from the very beginning, and that were part of Alan Meltzer's vision. Another part of his vision was that while economists are obviously, we all know, the smartest people in the world, well, not everyone thinks so. And in fact, there are other people out there who have points of view about these issues that aren't necessarily trained in economics. And so from the very beginning, this has been a joint collaborative effort where economics, broadly defined to include political science and economic history, has been allied with legal scholars, initially Ken Scott, and now Michael McConnell. And I think I speak for Michael, but I'll let him speak for himself in saying that we really learn a huge amount from each other. We do, and that we also learn a lot from our colleagues from other disciplines. So I won't take any more of your time except to say that it's just been a great pleasure to be part of this for 5 years. I hope we will continue, and that's really the spirit, the motivation, and the interdisciplinary commitment that has motivated this from the very beginning. So thanks for your attention. I'll now turn the floor over to my colleague, Mike McConnell, who will give his introductory comments and then chair the session. Thanks, Mike.
Well, thank you, Charles. Only 5 years. And yet so much has changed. When we first began meeting, many of our principal concerns were about ways in which the regulatory state had become thoroughly embedded, how it was avoiding checks and balances of the system. And I don't mean just constitutional checks and balances, but Administrative Procedure Act balances, so that through Charles mentioned regulatory guidance, but a number of different ways in which the regulatory state was evading restrictions that come from the rule of law in various ways. Well, here we are, 5 years later. My guess is that still takes place to a certain extent, although there have been, I think, some major moves to cut back on some of those issues. But other issues emerge that seem, just as perplexing and just as concerning as the ones we started with, but in many ways like 180 degrees away. And so the content of the theme of our program is exactly the same as it began, but the content is very different. And so today, for example, the morning is going to be devoted to a phenomenon that simply was not occurring 5 years ago when we began. I'm historically minded, although I'm only a lawyer, but I'm historically minded. And usually I go through life, people talk about new problems and so on, and usually I go through life saying, well, actually, we've had this problem for 300 years, and here's what Hamilton had to say about it, and there's nothing new under the sun. I actually think there is something new under the sun in the last several years, and that is the spate of lawsuits in which plaintiffs, oftentimes state attorneys general, using the resources of the taxpayers of their state, and often with respect to matters that don't have any, shall we say, direct relationship to state government, although of course they may very well have relationship to the lives of the people within the states. But often these cases have been brought by state attorneys general. This started to a certain extent under President Obama, where the state of Texas was taking the lead, but it has metastasized under President Trump, where it's hard to know who's taking the lead, but I guess if you just count cases, I think California now has over 50 cases proceeding against the Trump administration. So this is a new and very interesting phenomenon, and related to it is the phenomenon of district judges taking jurisdiction of cases, often with fairly dubious, by which I don't necessarily mean wrong, but aggressive understandings of standing and jurisdiction, and then entering nationwide injunctions, often quite rapidly. And so major initiatives of the executive branch that in earlier eras would become implemented, and they might be challenged down the road when they have actual effects, are being challenged immediately by state attorneys general, and finding district judges willing on preliminary injunctions to stop them in their tracks. And then what happens? Well, time happens, right? Because many of these might down the road even be overturned, but it takes time, and that means that the branch of our government that Hamilton described as having energy, secrecy, and dispatch is stopped in its tracks. So it's deprived of energy. It can't enforce what it wants to do. The idea that it is able to maintain confidences is one of the biggest issues in the law as we speak. And then dispatch. Well, there's not much dispatch if virtually every initiative is stopped in its tracks for several years and has to fight its way through multiple layers of judicial decision making. So our first two papers this morning are about two aspects of this problem, quite different aspects, technically speaking, but I think they fit together in terms of their functional significance for this new world that we're living in. And so Tara Grove of William and Mary Law School is going to be giving the first paper, and that is on the subject of states, that is state attorneys general as policy litigators. And maybe, Tara, why don't you come up, and her respondent is going to be Professor Will Baude of the University of Chicago, at least now of the University of Chicago. And then the next session will be on the subject of nationwide injunctions.
All right, so thanks very much. Thanks to Charlie and Michael for putting this together. Thanks to Will and all the other commentators for commentating today. And thanks to all of you for coming to talk about some of these issues. So Michael gave a very nice warm-up to what I'm going to talk about. There is a phenomenon today that would have been unimaginable 10 or 15 years ago. States are suing the federal executive over the implementation of federal law. So as Michael referred to, Texas and 25 other states brought suit against the Obama administration, challenging its deferred action program. States have also challenged President Obama's environmental policies. States are suing the current administration over environmental policy, the travel ban. Some states filed suit against the Trump administration, arguing for the rescission of the Deferred Action for Childhood Arrivals program. Other states sued the Trump administration when the administration did rescind the Deferred Action for Childhood Arrivals program. And just 3 days after President Trump issued his declaration for a national emergency, stating that he was going to build a wall, 16 states brought suit to challenge that presidential action. The number of state plaintiffs in that case is now up to 20. So this is a growing phenomenon, and it's one that has really taken off in the last 5 years. Now, there are a lot of things that one could say about these lawsuits, but what I want to focus on is whether these state plaintiffs have the power to be in court at all. In legal terms, that's whether they have standing to be in court. And just to give you the punchline up front, I'm going to suggest that states should not have broad power to sue the federal executive over the way that the federal executive implements federal law. Now, before I get too deep into that, I want to give you guys a brief overview of standing doctrine. I know there's some non-lawyers in the room, and your reaction to this may be similar to my mom's reaction when I told her years ago that I was going to write a paper on standing. She said, "Oh, and your next one's on sitting, and then walking." And even for the lawyers in the room, it's probably helpful to have a refresher. So I just want to start off with an example. Let's say I get up. I walk over, and I bonk Will in the head with a book. So let's say I do that. So I bonk Will Baude in the head with a book. Now, can he sue me? Well, I hope everyone's reaction, lawyer and non-lawyer alike, is, well, yes, of course he can. In standing terms, we would say that Will has suffered an injury caused by me, and that he can get a remedy, probably by suing me for money damages. By the way, I'm judgment-proof. But he can. These are the elements of standing doctrine: injury, causation, and redressability. So that's the easy case. Let's extend it a little bit further. Can Michael sue me after I bonk Will Baude in the head with a book? Can any of you sue me? Now, I didn't hit any of you in the head with a book, but Michael, for example, is sitting right next to me. Maybe he has a very reasonable fear of future harm. After all, if I'm going around if I'm going around bonking people in the head with a book, who knows who might be next? The person sitting next to me? And maybe anyone in this room could be in danger. Or maybe each one of you in this room, particularly Michael, felt emotional harm after seeing Will hit in the head with a book. The emotional... Maybe you don't have so many friends after all. The emotional harm, of course, augmented, especially for Will, when he sees that I hit him in the head with the Federalist. So, it's a little bit harder, but maybe anyone in this room could sue me for hitting Will in the head with a book. Let's extend the hypothetical a little bit further. Let's say a woman in Maine turns on the television and sees the headline. Crazy law professor from Virginia hits Chicago law professor in head with book. Now, she is livid. She's apoplectic. She cannot believe these horrible acts of violence are occurring, or that they're on her TV news station in Maine. Can she sue me? I hope people's reaction is no. Now, this woman may have a genuine emotional reaction and may feel very strongly that no one should commit acts of violence anywhere in the world, particularly not crazy law professors. But in standing terms, we would say that she has an abstract and generalized grievance. Anyone could be upset that there are acts of violence happening in the world. But under current law, a private party cannot sue about that. And what I want to underscore is this is black letter law. One thing people say about standing doctrine is that it is utterly unclear, and that there's some truth to that. But this is 100% clear. If this woman in Maine brought suit against me for hitting Will Baude in the head with a book, 9-zip, the U.S. Supreme Court would hold that she does not have standing. That is an abstract, generalized grievance. She has no greater interest in the matter than anyone else in our society. So that's the law of standing for private parties. Things get a little more complicated when we move into the government. So let's talk about state governments. Now, sometimes state governments look a lot like private parties. States own property. People can trespass on that property, and that's a really concrete harm, kind of like getting hit in the head with a book. States also engage in contracts. And when people renege on those contracts, or states think they've reneged on those contracts, states can sue about that. So in that way, states are just on the same plane as a private plaintiff. But there are some situations where states can bring suit even when private parties cannot. States enforce their laws and defend their laws, including in federal court, all the time. When a state law is challenged on First Amendment grounds, Second Amendment grounds, as a violation of the Equal Protection Clause of the 14th Amendment, there is no question that the state can defend that law and appeal a lower court decision striking down that law. This is so well accepted, courts don't even talk about the ability of states to be in court in those types of cases. Well, what I found is that for a good portion of our history, once states were allowed to be in federal court, lower federal court, entirely, states could also sue the federal government when the federal government tried to preempt a state law. That means a federal law supersedes a state law and basically makes the state law go away. States could sue over that too. And what I've argued is that actually makes a lot of sense. Because a federal preemption is very similar to a lower court decision striking down a state law. Either way, the state can't do anything to enforce its law, and the state has the power to sue over that. States in our system do have a special and, one could say, particularized interest in the enforcement and continued enforceability of their laws. Now, fast forward to today. The lawsuits today look very different. In most of these cases, states are not suing the federal government to protect a state law. They're suing the federal executive to control the way that the federal executive implements federal law. That is what is happening in the cases over the Deferred Action for Childhood Arrivals program, both those who want to keep DACA and those who want to get rid of DACA. That is what is happening in the lawsuit over the President's emergency declaration. And what I want to suggest is that states have no special interest in the way that the federal executive implements federal law. Yes, state attorneys general may feel very strongly about what the president does and does not do, just like the woman in Maine feels very strongly about crazy law professors hitting other law professors in the head with a book. But state attorneys general have no greater interest in the way that the federal executive implements federal law than anyone else. Now, the Supreme Court said differently, or may have said differently, in a case called Massachusetts versus EPA in 2007. The Supreme Court suggested that states should have should get special solicitude in a standing analysis when they sue the federal executive over the way that the federal executive implements federal law. Now, the Massachusetts case doesn't have to be read that way. But in 2007, the decision came at a time when state attorneys general had become much more prominent players in state government. Their offices were better funded. They were stepping stones to higher office. And what better way to get political appeal within your state and without your state than by challenging your political opponent on a national stage? And so whatever the Massachusetts decision meant, the decision seemed to invite state attorneys general to bring suit against the federal executive. And I think that's one of the reasons that we see the explosion that has happened in the last 5 years. But what I want to suggest is not only do state attorneys general not have a special interest in the way that the federal executive implements federal law, but that these lawsuits are also problematic on federalism grounds. Now, in a way, that seems counterintuitive, right? Federalism would seem to say that state government should have more and more power, including the power to sue the federal executive. But think about what these lawsuits are doing. States like Massachusetts are suing to get the federal government to be more aggressive in environmental protection. States like Texas are suing to get the federal government to be more aggressive on immigration. By contrast, Texas and other states opposed the lawsuits in Massachusetts versus EPA and other cases, saying the federal executive should take a more deregulatory approach, and Massachusetts and other states tried to say that the federal executive should take a more deregulatory approach when it comes to immigration. Through these lawsuits, the state attorneys general are reflecting something very fundamental about federalism. States have different views of the common good. They have different views of good policy on issues like environmental protection or immigration or health care. And this is a central value of federalism, that states can pass laws that reflect their constituents' vision of the common good. But through these lawsuits against the federal executive, states seek to impose their own vision of the common good on the nation, a problem that is accentuated by the rise of nationwide injunctions, which Professor Bray will be talking about very soon. States should not be allowed, should not have a special power to impose their vision of the common good on the nation. Now, I want to say one final thing about these lawsuits. I think these lawsuits against the federal executive are a symptom of a larger problem in our society. The desire to send more and more controversial issues to the courts. And this is true of a lot of governmental actors. The U.S. House of Representatives has been suing the administration. The Republican-controlled House sued the Obama administration over the Affordable Care Act and various other things. Currently, the Democratic-controlled House of Representatives have been suing the Trump administration over things like the border wall. So this is part of a growing phenomenon, government institutions trying to take controversial issues to the courts. And it's a symptom of a broader problem that people have lost faith in the political process. In fact, state attorneys general themselves say that their lawsuits are designed to make up for a dysfunctional Congress. State attorneys general have said, look, Congress can't check the executive branch and someone needs to. So let's go to court and get the courts to do it. The courts can help fix our broken political process. What I want to suggest to you is that federal courts cannot perform that function. This argument overlooks the extent to which judicial power and judicial independence depends on the political branches. A functioning Congress needs to give enough judges to make the federal judiciary work, enough federal jurisdiction for the federal judiciary to work. There needs to be a president to nominate judges and a Senate to confirm judges. And there needs to be a Congress who will not take away federal jurisdiction, impeach judges, or pack the Supreme Court. Judicial power and judicial independence depends tremendously on the forbearance of political actors. And so I want to suggest to you, the federal judiciary cannot fix a broken political process, because judicial power and judicial independence can only exist. We can only have a functioning federal judiciary if there is already a reasonably well-functioning political process.
So I agree with a lot of the things Tara has said. Among other things, as another scholar of federal courts, I agree that these technical concepts like standing and federal jurisdiction and so on turn out to be really important because they, even if a lot of our family members don't totally understand what they are and why they're important, they do a lot to affect what kinds of cases can be in federal court and when and what kinds of interests, and federal courts in turn will decide what kinds of policies the government can implement, and that has major consequences for our polity. And so I think I also agree with the general diagnosis that states are now using federal lawsuits as basically an extension of our protracted national political debates. They're basically trying to judicialize, to use Tara's phrase, a huge amount of policy and politics. I think Michael's right that this is happening also at an increasing speed, and that itself is causing new problems, so that it does pretty much seem like any administration now, when they roll out a major initiative, the very first thing that will happen is Texas or Hawaii will sue in Texas or Hawaii in a federal court, and some court will issue a nationwide injunction, and then, before anything can happen, it has to all be pre-cleared by federal judges around the country and possibly reach the Supreme Court in an emergency posture, and then we sort of have to get the court sign off on everything before we do it. Sort of like an out-of-control constitutional court from another country, where constitutional courts in other countries often sit and kind of review legislation before it's enacted in a kind of advisory capacity. And now our courts seem to be doing that for everything important. So that seems like a big change. And I think even in I think it seems like a big change. And I think Tara's proposal that we should treat states like everybody else when they try to sue, and only let them sue when they have either been hit in the head with the book or when something they have special power over, their laws have been preempted. I think that also makes sense. So I agree with the solution. I'm not convinced that the solution will actually cure the problem. I think our problem may be much bigger for reasons that are both sort of technical and then a little more big picture. So I'll just talk about that for a second. So on the diagnosis, again, I think it's right that the states right now are almost acting like almost like a fourth branch of government, as a kind of a permanent government in opposition who've been appointed to be the devil's advocate for every major policy. There are always going to be some states that are controlled by people who strongly disagree with whatever the administration is doing. And so there will always be some states that are ready, willing, and able to try to stop it and to bring suit. And that's something we don't let, for example, the houses of Congress do. It's a core principle of standing that we have not yet abandoned, that a House of Congress can't just run into court when they don't like what the administration's doing. The circumstances where Congress can represent itself in court are very narrow. And for good reason. We don't think that sort of every fight between the branches or every government shutdown or every piece of gridlock should suddenly rush over to the Supreme Court for their answer. But we're letting states do something sort of analogous, and that does seem, I see why that's troubling. It seems to be accentuated by polarization, and now accentuated just by the political salience of these lawsuits. And in Tara's paper, she has a bunch of great examples of state attorneys general sort of running on the fact that a huge part of their platform is suing the president, which is popular in their state, and almost makes it seem like their job description now is to be a troublemaker. And I also think, to pick up on Michael's earliest comments, that this is something in the 300 years of history sweep, it's something new. Once upon a time, I think the fear about federal courts was that they were going to be the lackeys of the federal government, and that they would be, it was both the fear and the hope, that they were important to making sure that the national government could carry out its policies and programs, that if we didn't have them, if everything was left to state courts, or if there weren't federal courts, the federal government's ability to enact things would be hamstrung. And so having people who were life tenured but appointed by the national government was important to be able to administer justice throughout the country. And now it seems like the opposite is happening. It seems like the federal courts are being used as the kind of guerrilla warriors against whatever the government of either party is trying to do. But so first in technical terms, I guess I'm skeptical ultimately how often these state lawsuits, all of which are also cataloged in Tara's paper, are actually based on a theory of standing that requires sort of special solicitude. That is, a lot of the time, the sort of salient suits by states, the whole theory of standing was either that the states were hit in the head of the book, or had their money taken, or had their laws preempted. So when Texas sued to challenge the president's deferred action program, their theory of standing was a combination of either our money is being taken because we're required to spend money that we wouldn't otherwise be required to spend, or our laws are being preempted because our attempts to to issue driver's licenses and have various regulatory programs they want to have won't work if this new regulation is in place. Or when states sued to challenge President Trump's travel ban. The state of Hawaii's main theory of standing was that they operate the University of Hawaii, and the University of Hawaii wanted to have visiting students and scholars who now couldn't have under the travel ban, which if a private university brought as a theory of standing, I think 8 justices would say that was a totally orthodox theory of standing under current black letter standing law that doesn't require any special solicitude on the part of states. And I think it may not be true for every lawsuit on the list, but I think it's true for most of the lawsuits on the list that the states ultimately have some either fiscal or sort of theory of preemption. So while it would be a good idea to treat states the same way as they have been historically, I'm always in favor of returning to the historical baseline just on kind of rule of law grounds. I worry that's a Band-Aid, or it's a thing worth doing on its own right. But we shouldn't be under any illusions that if the courts all listen to Tara and do this, that this problem of these lawsuits or over-judicialization is going to stop. Even if I'm wrong about some of the specifics of these lawsuits and the states can't always be plaintiffs, I suspect I think, as far as I can tell, in all or almost all of them, still somebody else can be a plaintiff. So if the advocates trying to organize a state lawsuit against the contraception mandate or whatever the next policy is can't get a state as a plaintiff, they can probably get somebody else using an association or a carefully picked test plaintiff. Just the sophistication behind finding plaintiffs is sufficient that it seems in almost all these suits, maybe all, that if we say to states, you still have the sort of normal historical rules, either they'll still be able to sue, or even if they can't, they'll find somebody else who can. And so we won't really be free of any of these lawsuits, is my fear. And if maybe we'll be free of 1 or 2 of them, but we certainly won't be free of the bigger problem. Now, again, I think that's probably worth doing on its own right. It's worth not casually expanding our rules of standing and trying to adhere to the ones that we've got as a matter of sort of history and tradition and law. But I wouldn't be too optimistic about what'll happen if we do that. Now, I still agree. So I'll just say that that's the technical side. On the bigger picture side, that just makes me all the more nervous and eager to try to figure out, if this won't fix the problem, what will? Or if this is one of 10 things that will fix the problem, what are the other 9? So with apologies for broadening our ambit a little bit, I'll just say a little bit about that. I think over-judicialization of policy is a real problem. Maybe we need, as the next panel will talk about, reform of nationwide injunctions so that when Texas or Hawaii or other states do rush off to their local friendly federal court and get an injunction, it only benefits Texas or Hawaii and not everybody in the country. I'm not sure whether that's going to fix the problem either, and there'll be a debate about that shortly anyway, so we'll see. Maybe we need broader reform of standing. Maybe part of the problem is that now everybody, private people and states alike, can sue over things that are more tenuous than just being hit in the head of the book, and more tenuous than just having a contract broken. And so maybe we really need to kind of dramatically limit when anybody's allowed to sue, not just states, but environmental activists or Tea Partiers or organizations. Maybe we just need to reform all of that. Maybe we need a stronger rule of what's called ripeness, which is not about exactly whether you can sue, but when. So respond a little bit to the concern that people are all suing over major rules, often before they even go into effect and deprive anybody of life, liberty, or property. Maybe we need to slow that down. so that the government can implement its rules first, and then we only challenge them later. I think that will lead to some other headaches we'll regret possibly if we do that, but it might help solve this problem. Maybe we need some broader reform of injunctions in general. We need to make them harder to issue, or we need to bring back this the archaic idea of the injunction bond, where if you get an injunction, you have to pony up a bunch of money that you might forfeit if the injunction gets overturned, so you don't ask for it too lately or just to cause trouble. Maybe we need some other kind of timing regulation. Maybe we need ways to get the appellate courts in sooner so the district courts can't do it. I'm not sure. But as I add up the possible spate of reforms, I just worry that states may be leading the charge, but there's a big enough army of plaintiffs right behind them that even if we took the states out of the mix altogether, it wouldn't totally cause the problem. I'm not normally a pessimist, though, and I'll just say I do end even thinking of all this list a little bit pessimistic, and I wonder if the real problem is something that none of these things can fix. If the real problem is just two features of, I guess, supply and demand. One is that our representatives and people in the administration seem to take adherence to the law less seriously or less cautiously than maybe they once did. So there are just a lot more things by both administrations that are legally tenuous than there used to be. And that's a problem that's not the federal court's fault, but it's a broader fault that we might need some broader reform to fix. And then also federal courts seem to be more willing to grant relief. Maybe that's just because there are more tenuous things than there used to be. Maybe that's because on the flip side, the federal courts have also just become a lot more accustomed to this role of being guardians of our country's national policy, and they're happy to do the job. But if that's the problem, if the problem is we just have too much illegal stuff going on and federal courts too willing to do stuff about it, then I think kicking the states out of the courtroom is not going to stop any of that.
All right, so thank you very much for those comments. I think it's very hard to see into the future and see what will happen if the law were different. I think the law would look very different if the Supreme Court said in Massachusetts versus EPA, we did not intend to give the states special access to the federal courts. And even if it looked that way, we're saying now that states should not have special access to the federal courts. Now, I think Will notices something really important about recent cases. In the early cases, sort of when this explosion began in 2014, court said, well, we're going to give the states special standing. And so they get a leg up over private parties. In some of the more recent lawsuits, states have said, well, we get special standing, but guess what? We don't really need it because we have a financial injury. And so in some cases, I think they probably do. I think there's a pretty good argument that a state university suffers a financial injury if it can't get students from across the world because of the president's travel ban, or at that time couldn't, because of the president's travel ban, and could sue over that. But then if states don't get special access, I think that really causes courts to take a look, well, what would we do if a private university sued over this? Would we allow a private university in Hawaii to sue over the ban in the entire country? Would we allow a private university in Virginia sue over what the president does throughout the country? I think some of the special solicitude that states have been getting has also gone into the area of remedy. Some scholars think this is a good thing. This anticipates some of what Sam Bray is going to talk about in a few minutes. But I think if the courts made clear, no, states, you don't get a leg up, and courts were really required to look at what they would do if a private party brought a similar lawsuit, that would matter a tremendous amount. In the recent challenge to the president's contraception rule, the states are arguing that if women do not get contraceptive services through their employers, they will go to the states either for the services themselves or the states will be responsible for the costs of unintended pregnancies. Now, in standing terms, courts tend to get nervous, at least when private parties bring the lawsuit, when claims become speculative. And the reality is it's not exactly clear what private parties would do in the absence of insurance coverage. And I think there's a real question as to what courts would do if a private party brought a lawsuit against the federal executive saying, federal executive, you need to enforce the law against a third party because of what might happen, what might happen to us. I think there's a real question as to whether that would be deemed to be too speculative. And interestingly, in one of those cases, the court found that it could grant state standing only with special solicitude. In another case that raised exactly the same claim, the court said, oh, states get standing without special solicitude. So I think what you see here is potentially special solicitude mattering at the outer rims, even if courts are not explicitly relying on it. And I want to emphasize, I'm not saying anything about the merits of these lawsuits. I suspect that many of us in this room feel very differently about the merits of these lawsuits. All I'm focusing on is whether states should be able to go to court. As for the preemption challenges, it is true that federal law often preempts state law. But what I have found historically is that when a state brought a preemption challenge, the only thing that the state could ask for was to get a court ruling on whether its law was actually preempted, which meant the only redress that the state could get was to be able to enforce its law again within its own state. So in the Texas challenge, the deferred action for to the DAPA program, deferred action for parents of U.S. citizens or lawful permanent residents, part of Texas's challenge was based on preemption. But if Texas was bringing a preemption challenge, saying that, hey, we have to issue these driver's licenses, the only thing that Texas could get in a preemption challenge is a ruling on whether the DAPA program preempted Texas's law. And the remedy it could get, if it prevailed, was a ruling that, hey, we can issue driver's licenses to whomever we want. But what Texas asked for in that lawsuit was a ruling on how the president could execute the law nationwide. A preemption challenge does not get states where they want to go. And so I think it would help. I don't, however, think it would solve the problem. I've written a lot about lawsuits by government institutions, not just states, over the past few years. And I think they are part of a growing phenomenon, a growing reliance on the courts. And I think the courts themselves need to stop being so open to government lawsuits. It is true that the U.S. Supreme Court hasn't ruled in the House of Representatives standing, but two different federal district courts have come out on the opposite way on that issue. Some allowing the House of Representatives to bring suit, some saying no. And I think courts really need to put a stop on those things and probably need to be a lot more careful about remedy and other things. But I also want to underscore, if we do want to open the federal judiciary, I tend to be on the side of folks who think we should have a more limited federal judicial power and federal judicial role. But if one has a different view, which is a perfectly valid alternative, the lawsuits should be brought by private parties. What we've seen in the last 15 years is the Supreme Court cutting down on private parties' ability to get into court and increasing the power of state governments to get into court. And to me, that seems exactly backwards. Maybe we should limit the judicial role overall or expand the judicial role overall. But if we do expand the judicial role, the lawsuits ought to be brought by the people who the federal Constitution and our legal scheme is designed to protect, and that is individuals.
So thank you. I'm going to be keeping a queue, and Jennifer will be the very first name on the queue. But first, if I may, I'd like to just pose a question for each of the speakers. And to Tara, my question sort of rose in her very first few sentences when she was stating her thesis, and she said one of the things she'd be arguing is that the states should not have standing to challenge the federal implementation of federal policy. And so my question to Tara is, what does the word should mean? Does that mean that you are proposing a change that is under the current correctly interpreted law? The states do have standing, but they shouldn't, so we need to change our doctrine of standing? Or is it that you believe that the states under our current doctrine of standing don't have standing, and we ought to just be more careful and accurate in our interpretation of current law? I mean, are you proposing a change, or are you demanding that we stick to our current doctrine?
So that is a great question, and I think it depends both on whether one thinks doctrine comes from the Supreme Court only, and exactly what the Supreme Court has said on this issue. As I told you, in 2007, the Supreme Court declared that states get special solicitude in the standing analysis. But for the lawyers in the room, it's not clear that the decision actually depended on that statement. Massachusetts in that case claimed a property interest that looks a whole lot like getting hit in the head with a book, and parts of the decision seem to treat Massachusetts just like a private party. Other parts of the decision seem to give Massachusetts a leg up. My own view is the decision did, in fact, give Massachusetts a leg up, in part because of the oral argument. Justice Kennedy said, well, okay, we're not saying a private landowner, even of a large amount of land, could bring suit, right? We're saying that Massachusetts can bring suit. And so at least if you look at the oral argument and the context of the case, it looks like Massachusetts was getting special treatment, but it's not clear. So if Massachusetts did give special treatment to the state, then this requires a change in the law since 2007. If one disagrees with that interpretation or thinks that it was just unclear, all the Supreme Court has to do is clarify a misunderstanding in the lower courts of a 2007 decision. I think if one looks at the lower courts are very receptive now to assertions of state standing. And I think this does require a change in the outlook of the lower federal courts. But this is an outlook that's only existed since at most 2007, and really the lower courts have only been on this trend of granting standing since about 2014.
And so a question to Will. Will said at one point that the states are becoming like a fourth branch of government and a permanent opposition to anything that's going on in Washington, and since nothing goes on in Congress, I guess that means things going on in the executive branch in Washington. And my question to you, Will, is this really a bad thing? Now, I realize it's a transformation from the way in which our founders understood that the states would be a source of resistance to oppressive federal policy. Madison did not expect the states to file suit. What he expected them to do was to organize the way they did against the Alien and Sedition Acts and but nonetheless, not just in 1798, but earlier in the Federalist, and any number of places in the Federalist, Madison in particular, I don't think Hamilton believed this, but Madison did, that the states would be a check against the federal government because they would be a place where political organization could take place. Now, this is before there were political parties, and Madison was not a very good predictor of what actual on-the-ground politics in a democratic republic were going to look like. But he did think states would be the locus of this fourth branch of government. Yeah, they are a fourth branch of government. That's federalism is part of our constitutional scheme too, and a permanent opposition. Well, yes, some of them. The great advantage of states is that they are diverse. We have, at the founding we had, slave states and free states. Now we have red states and blue states and purple states and agriculture. The states are different, and that's what makes them so important and interesting as part of our constitutional system. So what's really wrong with this? Isn't what we're now seeing just a new, 21st century version of exactly what Madison had in mind for the role of the states?
Yeah, maybe. I think I also say I found myself nodding as you're saying a lot of that, and certainly for a lot of.
I didn't believe a word of it, by the way.
I think you just you're trying to trick me by saying something I believe, luring me into agreeing, and then I'll expose myself as a radical. So I think I see a lot to that, but here are two of my worries, I guess. Besides the fact that it's new and anything new makes me nervous. One is the judicialization aspect. So I think it would be one thing if the states were, sending, writing their Virginia and Kentucky resolutions again, or sort of like engaging in national politics and sort of being part of a political platform and reminding people that not everybody is on this side and putting forward a different set of values and all that stuff. I do think that when the states are responding by running off to federal court all the time, that seems to have some worse consequences on for our politics and for our governance, which is maybe where I ended with this sense of the over-judicialization as part of the thing I'm really worried about. But even apart from that, here's the other thing that makes me nervous, is the effect of this attitude on state and local democracy. So election law scholars who know more about this than I do report that more and more state elections, and especially local elections, are just shadow elections on national politics. Even in places where there are real political issues and there might be multiple candidates or a primary candidate, like a lot of what voters end up caring about is which candidate is going to enact a resolution against whatever it is the national government is doing, or which candidate is helping sue the government a lot, or certainly the partisan affiliations line up. And if you have elections that aren't in the same cycle as the national election, nobody votes in them anymore. And if they are in the same cycle as the national election, everybody just votes for the things they care about at the national level. And I worry that it's really impoverishing the ability of to have real democracy and real control over what states and localities do as a matter of policy. And so you get more and more of just a really thin and bad set of governance at the state level. And that seems like it should be part of federalism too, at least, is to have relatively well-functioning governments in the states that remind people that lots of things can be done competently by the states and don't need to be done in Washington. And I worry that the obsession with being for or against whatever the national government is doing is making that a lot worse. That's what the election law scholars report to me. It seems consistent with my anecdotal experience, and if that is true, that it may not be worth what we're getting.
Of course, that also is a return to the original Constitution. Prior to the 17th Amendment, the state legislatures elected the Senate, and that had the effect of nationalizing state politics. Why were Lincoln and Douglas running around Illinois debating? They weren't running for the Senate because there was no popular election for the Senate. They were running around the state debating to get people to vote for their parties for the state legislature so that they would then be elected to the Senate, which means, I think, in the pre-17th Amendment era, our Constitution really was designed, maybe not intentionally, but a clear institutional effect of our original Constitution was to orient state politics around national politics. Probably why we have such a strong two-party system today. But
So you're
time
telling
for
me
me to subside and to start doing my job, which is handling the queue and beginning with Jennifer Arlen.
So it's a very interesting paper. I think you could strengthen the paper by dealing with the issue that Will raised sort of in passing, which is what is actually triggering what the states are doing. And you frame it in a way that makes your life easy, which is it's just a difference in policy. You've got now a Republican president, Democratic state attorneys general. Before we had a Democratic president, Republican. But I think he's right. That's not actually what's triggering it. And I would call you back to the first Rule of Law conference. And Professor Rabin has a really nice piece framing that conference on what's new, which is the rise of the assertion of executive power, not through formal rulemaking or even informal rulemaking, but through other things that really pull it out of what we would think of as the rule of law, informal adjudication, or just broad assertions of Congress says do X and I'm just not enforcing that. And it's not that states disagreed with, just that they disagreed with Obama over immigration policy, but arguably if Congress says do X and Obama says I'm not enforcing it, that's a big rule of law problem. And a lot of what Trump's doing, I mean, you raise the wall like this is a policy issue. No, Congress said we're not funding the wall, and then Trump said, I am. The problem isn't policy. It's the executive bursting out of the constraints imposed on him. So I think when you write your paper, I would like to know, do you really hold to your guns in a world in which the president is arguably acting illegally, and I raise both of them? I mean, I'm not, and
Right.
I think that raises different issues, particularly when you say the court shouldn't be intervening, we should leave it to the political process. Well, what the first rule of law conference was about was, you know, is the current political process constraining the executive within the rule of law? What happens when the executive is no longer within the rule of law? And then who can intervene? Putting that burden on individual citizens will not get the executive back into the rule of law, because the problem is not that I, Jennifer, am impacted. The problem is the executive is acting illegally. I mean, I'm being nonpartisan here. I'll blame them both. I'll go back to Bush and blame him too. I really dated, So, and I think he's also right that if you go and look, the states have a vested interest in all of these things. I mean, if Trump says, I'm not going to enforce the individual mandate, that wreaks havoc on states' states make commitments on Medicare, they expand it out. The individual mandate directly impacts the cost effectiveness. And while you shrug on the whole issue of abortion, there's, to say that it's speculative, it's not speculative whether women's ability to get insurance payments for abortion. You could say, I don't, fine, I don't care, but it's hard to say that's a speculative injury, that if they can't get insurance funding, it's going to impact their ability to do these things. So I'm just saying, I think you may come down in the same place, but your paper would be stronger if you come down in that place addressing the really hard question that he raised, which is, do you feel the state AG should be out of it if the executive, both parties, is actually acting contrary to the constraints that Congress put in place, and Congress can't intervene?
So I think this is a wonderful question, and I think the rise of executive power, executive overreach across administrations, and I agree that that's a bipartisan problem, is the central separation of powers problem in our society. It's a problem that started before 2014, before the explosion in state lawsuits, and so I think there's still a question of, well, the problem existed. In fact, there's been a rise in executive power for many decades, an explosion over the past several presidencies, and yet there weren't state lawsuits. So I think we need both in the picture. Clearly, people are concerned about the rise in executive power, and clearly state attorneys general are responding to that, but they didn't do that initially. And I think there's a question of why that is. And I think the other point, a couple of other points, I agree that it's a real rule of law problem. As people who know me know, I'm a rule of law person. My legal views rarely line up with my political views, and I just want to be clear about that. I'm proposing this as a bipartisan measure. But state attorneys general are not across the board defending the rule of law. It was Republican attorneys general, almost exclusively, with Republican governors who brought suit against the Obama administration, saying the Deferred Action Program is unlawful. Other states, Democratic-led states, intervened to say, actually, the Deferred Action Program is in the public interest. And many people in our society agree with one or the other. Now it is Democratic attorneys general who are challenging the border wall. The border wall may very well be an incorrect assertion of executive power. But if so, why aren't Republican attorneys general challenging it too? So attorneys general are not simply standing in for the rule of law, they're also standing in for different views of policy. And that, I think, should give us pause in terms of relying on attorneys general simply to defend the rule of law. But who could challenge it?
Who can challenge it?
And so I think, depending on the issue, there are private parties who would have standing or will have standing eventually, particularly on the border wall, if the president takes private property, as undoubtedly will have to happen, private parties will be able to challenge that, and there will be a judicial ruling on the legality one way or the other of the border wall. Now, a private party may not be able to bring suit 3 days after the issuance of the Declaration of National Emergency, but depending on one's perspective, that could be a good thing to wait on the intervention of the judiciary. One of the things that I think just to anticipate Sam Bray's paper, our society decided that federal court review would happen after the fact. There are societies that allow immediate judicial intervention or even allow the judiciary to judge the constitutionality of a statute of their federal legislature before it's implemented, before it ever goes into effect. But that's not the society that we have chosen. As for a judicial check, I get this question a lot, and this just to put my cards on the table. I have argued against standing for members of Congress. I've argued against standing for the House of Representatives or the Senate. I've argued against standing for state attorneys general in states. I've argued for limited standing for the executive branch. So there's a theme here. I'm kind of anti-government standing. And in this world, there are fewer people who can challenge executive action. And as someone who's concerned about the rise of executive action, I'm not too thrilled about that. But I do think people should think carefully about the reliance on the federal judiciary to stop the executive. Because when I get this question, during the Obama administration, I got the question from conservatives. Now I get the question from progressives, usually, not always, saying, well, then no one can challenge the executive. The assumption is always that the federal court ruling is going to go in one direction and one direction only, and that is to stop the executive. But that is not the way federal courts always rule. In fact, federal courts often uphold executive action for better or worse. And so going to the judiciary isn't necessarily going to stop the executive. It could legitimate executive action that one side or the other thinks is improper.
So let me pile on with Jennifer on this. Surely it's true that the courts are not always going to say no to the executive, but they might sometimes say no. But it is true that in the absence of someone to check the executive is going to get its way 100% of the time. And so I think Jennifer would ask, and I'm asking, isn't it better to have a judiciary who might even possibly in the best of all worlds be made up of people with a little bit more objectivity than the political actors deciding these questions than otherwise? And then to back it up to where Jennifer began, why not state attorneys general? One of your first answer to that was, in many of these cases, there will be a private party who will have standing. Well, let's take the cases where they won't. I don't know how many of your cases there are, but I mean, one of the odd phenomenon of the recent spate of cases is not just that states are being granted standing to challenge things that they probably wouldn't have been able to challenge before, but the private parties also are getting pretty generous standing rules. But I think the DACA legislation is an example of, I don't know who else could have sued if it wasn't going to be the state of Texas. Massachusetts versus EPA, at least if Tony Kennedy's statements at oral argument are any indication, private parties would not have been able to sue. I think the Trump v. Hawaii litigation, nobody had standing to sue, but private university, I do not believe that a business has standing to sue when government action directed at its customers drive them away. So if I run a grocery store and the city is unconstitutionally, zoning my neighborhood out of existence, I don't think I have standing just because I'm not going to get customers. And neither does the University of Hawaii have standing just because some of its customers from foreign countries are being kept out. So I think there are quite a few of these cases where no one would have had standing, which means the executive goes unchallenged in court. Is that a bug or is that a feature?
So this goes back to one's view of how much federal court should be involved in making policy. Now, that will very much drive what one thinks about private party standing, because I think plenty of people think that private parties would have had standing in some of those cases, but certainly not all. My own view is that a more limited role for the federal courts is a better thing, and I don't think that means there are no checks on the federal executive branch. I'm struck by the fact that the U.S. House of Representatives has brought suit, a Republican-controlled House of Representatives brought suit against the Obama administration over its handling of the Affordable Care Act. A Democratic-controlled House of Representatives has brought suit against the Trump administration over the border wall. Well, these institutions clearly, maybe partly for partisan reasons, have a very strong incentive to check the executive branch. So why not focus more on the political process to do that rather than going to court? If the House of Representatives is willing to bring suit, then the House of Representatives can also be there to check the president. I think that the Senate, controlled by either party, also needs to be more involved in checking the president. And I think that the lawsuits themselves sort of give Congress an out. Well, we don't need to do anything because state attorneys general will sue the president 3 days after he acts. We, the House of Representatives, don't have to do this through the political process because, by golly, we can have our lawyers take the president to court. That, I believe, is not good for the political process itself. I think in our society, there will always be a check on an overreaching president. Now, that's not guaranteed, depending on the politics of the situation. But if the court valve is no longer open, or at least is not as open as it used to be, some private parties can sue, some cannot. I think that will impact the political process. I am increasingly rare, I find, in legal academic circles. I still have faith in Congress. And I think the only thing that will truly check the president in the long run is an enhanced congressional power. And I, for one, am heartened by the fact that people who were upset with the outcome of the 2016 election, many of them didn't run to court. They ran for office. To me, whoever happens to be in the White House, that should be the response of many, many citizens, to run for office, to campaign for people running for office, and to try to get a congressional check.
We have an unusual system in that we have the states represented in the Constitution, and we also have the individuals. So part of my question is why weren't they ever having standing? Why didn't they start doing this a long time ago? But there's also a time element to all these things. I fully agree with you that people who can run for office and things like that. And a lot of times that's what happens with legislation. But usually it takes a long time for the legislation to percolate its way through. But if you have suddenly presidents doing executive orders in less than 3 days, then why not give an opportunity to stop something in less than 3 days in the court system?
Okay, so I'll say, first of all, executive orders are typically not issued in 3 days, and this goes to some other research I've been doing. Executive orders take somewhere between weeks to months to years to get in because of the complex process for creating executive orders. Now, that's not a complete answer because it's still less time than legislation, but just as a factual point. I think it's a great question as to why this stuff didn't happen a long time ago. Now, one answer, a very simple answer may mean that states just had more trouble getting into federal court. An interesting factoid, in our system, state governments could not bring suit in lower federal court until 1875. Under the Judiciary Act of 1789, that simply wasn't allowed. States could sue, if at all, only in the Supreme Court's original jurisdiction. And from the founding up till the present, the Supreme Court has always taken a pretty narrow view of its original jurisdiction. And so during the Civil War, there were states that brought suit against the Johnson administration, challenging the implementation of Reconstruction. Mississippi brought suit, Georgia brought suit, and the court held on various grounds. People continue to disagree on what grounds, whether it was standing, what we now call the political question doctrine, or some ripeness or something else. It's not clear exactly why they couldn't bring suit, and it may have just been that the Supreme Court was not friendly to claims on the basis of its original jurisdiction. So that's the answer for much of the 19th century, at least part of the answer. I think another answer is political issues didn't get litigated in federal court as much. Many constitutional questions were debated in Congress, and that was the place where they were going to be resolved. And so there was not this sense of sending issues to the judiciary, whether it had jurisdiction, statutory or constitutional or not. But I think the important point is to look at what happened after 1875, and states could go to court. What I found is states did start suing, at least by the early 20th century, to challenge federal preemption. States did not bring the suits that they are bringing today. And to me, that history suggests that what we are seeing is something very, very new, undoubtedly related to the rise of executive power and concerns about executive power, but in my view, not the best response to concerns about executive power.
Paul Cunningham is my name. I just wanted to note, as a lawyer, that the debate is conflating a number of issues as it goes on. I think Will had the right idea. There are a lot of pieces to this. You're not to adopt Ms. Grove's proposition is not to give up the opportunity for states to challenge the federal government. It's to limit their role to that which is appropriate, I think, to a singular or group of singular state interests. She's not suggesting that states can't sue the president when he exceeds his executive authority, when the state is affected. Another proponent is going to be saying we should not have national injunctions, which is, I think, a logical extension of the same thought. But in the end, this is not about, it doesn't seem to me, maybe Ms. Grove would correct me, but it doesn't seem to be about limiting the ability of the states to participate in legal challenges to the president. It's about limiting their capacity to act other than as what they are, which is a limited party, akin to a private party. And if we're worried about private parties challenging, corporate interests, such as those that I've represented in the past and or opposed in many instances, are strong enough today, often stronger than any state, to mount an attack when there is a real impact on them. And almost any impact on a state is an impact on a major private corporation today in the United States, including perhaps DACA. So I think we have a lot of, we need to tie this down. We don't want the federal judiciary going beyond its rational capacities under the Constitution, nor do we want the states doing so, and we certainly want more congressional activism against the president. But let's not conflate limiting the state's role to that which is seems constitutionally mandated with giving up the opportunity to challenge executive authority. I don't think the two are properly conflated.
So I do think that states can challenge federal executive actions that preempt state law. And I give a few examples of that in my paper where executive action did preempt or significantly undermine state law. So in that way, states can challenge executive action. But I do say that states should not have the power that they currently seem to have to challenge the federal executive's handling of federal law. And I think that's where the action is. Now,
May I just ask, just to clarify something? I'm sorry to interrupt. You're not saying that the states can't sue have the same standing to sue that Will would have if he were affected, are you?
That's correct.
Okay.
I think that states should be put in the same position as private parties. And I will say, in that way, I disagree with some scholars who think that states should have less power to sue than private parties. But I do think that what's happening right now is that states are allowed to sue in cases where private parties could not.
So one important thing we also haven't talked about, and this ties into both this and Price's earlier question, is these are all limitations only on the federal court's jurisdiction. So state courts are also allowed to have their own principles of standing and jurisdiction that are not necessarily the same as the federal government's and are often broader. So if we did do this, and if there were a bunch of states eager to sue could no longer get into federal court, one set of questions we'd have to fall back to is when actually can states sue the federal government in state court? This was a big area of litigation in the 19th century, and there are some limits imposed by 19th century case law on states' ability to grant relief against the federal government. But there are still major unsettled questions, like even just the basic question of can a state court issue an injunction against a federal officer the way a federal court can? There's some authority saying yes, some authority saying no. It's a issue that hasn't been fully resolved. And to what extent can the federal officers take the case when it's in state court and force it into federal court? even if it's one of these cases where the federal courts wouldn't normally have jurisdiction. So if we did do this, if we do cut off the federal jurisdiction, just in terms of the theme of both everything has happened 300 years ago and there's always a new legal problem, the next round of questions would be, all right, can the Texas courts stop DACA themselves if the federal courts won't do it? And we can have a new conference on that.
My name's Tyler Allard. I'm just curious, if you don't seem to like this idea of special solicitude for states in the standing realm, how, if there's any interplay with, say, special considerations that states seem to get in other doctrines of the law. I keep thinking of Chief Justice Roberts' equal dignity concept in Shelby County, or, Justice Alito's, to my mind, very interesting and potentially interesting implications language in his NCAA versus Murphy, or was it Murphy v. NCAA, where he seemed to write that under his views of preemption, Congress now cannot tell states that they cannot legislate in a certain area. Or I don't know much about sovereign immunity, but in case that could also be a corner of the realm. So I'm just kind of curious how it might relate with other areas of the realm where it seems like we do treat states differently and quite special.
I think you just identified the origins of Massachusetts versus EPA. I think that people were very puzzled by that decision, but one thing people seem to agree on is that Justice Kennedy went with the majority and found standing for Massachusetts because of his general solicitude towards states in many of these other areas, including sovereign immunity cases and other areas. In terms of whether states are getting special treatment, I think that's a tougher question in these other areas. State sovereign immunity, of course, wouldn't apply to a private party. It only does apply to states. Ditto with Shelby County. I think a broader question, though, is how much are we going to stretch the federal Constitution to protect states? And I think that's the real question underlying cases like Shelby County and the 11th Amendment jurisprudence, because depending on one's perspective on that jurisprudence, courts have generously interpreted textual provisions to give power to states. And I think this is very much part and parcel of that. I am certain that I disagree with some members of this panel, and when I say that I am more skeptical of those textual jumps in those other areas. But I don't think anything that I say in this paper necessarily has implications for those other areas.
I just wanted to come back to Mike's question to Will and also Jennifer's comment about sort of, well, what can the states do, or who can do what? Well, we do have another aspect of the Constitution, which is that if 2/3 of the states really felt very strongly about the excessive assertion of executive privilege, if it really weren't a partisan issue, if it really were a process issue that they felt strongly about, presumably they could feel so strongly about it that they might decide to convene a constitutional convention. So I think it's interesting that the framers certainly did ask the question, are the states as a collective a fourth branch of government? And they are in the Constitution, but in a very limited way. And they're certainly not able to act individually to create law for the whole country. So I think that's also Will's point. So it seems to me that you might argue that we drew the threshold a little too strictly for them to act as a fourth branch, but certainly they do.
3/4.
It's 3/4.
3/4 to call a constitutional convention. So it's even higher. Maybe we should lower it to 2/3.
So, John, last question.
Yeah, this isn't a question, this is a statement.
For the record.
When we talk about buildings, we say there's the basement, there's the first floor, the second, right? That's the way to think about this, not branches, right? That there are three branches in the national government, and there's the state government, and they're part of the constitutional structure, right? And so states have typically adopted a three-branch notion even before the national constitution, but there really are floors rather than branches. They're not. I think that's the better way to think about it.
I think what both of these comments underscore, though, is that when our Constitution was designed, there were political mechanisms for states, the House of Representatives, the Senate, and the President to debate constitutional questions among themselves. And I personally think it's really important for us to remember that when we think about the scope of governmental power to go into court.
And Charlie was right, it's only 2/3. Sorry, mea culpa.
Thank you, Tara. Thank you, Will. We're going to have a 15-minute break and convene on